Mr. Brinkhead, you want?
All right, good morning. This is Senate Health and Welfare, and it is Rabbit, which means May 1st. So for those of you who do Rabbit, you know it's good luck on the first day of the month. First thing you say. Good. Don't forget that. This morning, we're looking at some bills that we really would like to make some final decisions about. And so H 121, we're gonna look at with our legislative counsel, John Gray, first. Just so you know, that bill is out of economic development, and anything we do would be a floor proposal amendment, probably third reading. I talked to Senator Ron Hinsdale this morning about that. So that's where we are with that one. And then we can talk about the others as we go through. But John, thanks for being here.
Sure.
We had a conversation yesterday. It would be helpful for you to frame some of the decisions that we're trying to make in here.
Yep.
Okay.
So, good morning, everyone. I believe it's May. John Gray, Office of Legislative Counsel. I'm going to be quick here. I just want to orient you guys who have principles in mind as you hear the next testimony from folks who are in much better position to give you like on the ground impact of this bill. So two particular pieces you're going to pay mind to of heightened concern: exemptions and the private right of action. Those are your two big decisions here. There are obviously other things you're attempting to do, but those are the two big ones. And these are intertwined concerns. So the private right of action raises the stakes for the exemptions. It introduces fear potentially that there's going to be additional enforcement. And so that fear can lead to steps to address the fear on behalf of businesses that are going to be subject to this, hospitals that will be subject to this. And what that does is it induces compliance costs. And so what I want to say is that those costs can either be justified or not, depending on how the bill is drafted. So if there's a lot of uncertainty as to application, folks who are going to be safe under the bill, but can't tell that they're going to be safe, are going to incur compliance costs that you guys do not want to impose. So that's one of the things you're thinking about here is how to not induce unjustified compliance costs. It's fine to induce justified compliance costs because that's what you're trying to do with this bill, but you want to make sure that you're not unfairly penalizing people who are trying to act in good faith. So I think it's also helpful to think about what actor should you be thinking about as you hear the next testimony. And there's kind of two hypothetical figures that are tossed around. We have the good faith actor, and then we have the bad faith litigant who's bringing frivolous lawsuits. And what I want to say is, I think you should really focus on the good faith actor and not so much on the bad faith litigant. And the reason that I say that is, while the bad faith litigant can be real, the extent to which they are meaningful for your decision making will be picked up by the good faith actor. If they have a reasonable fear that they're going to be sued on the basis of something that shouldn't affect them, that is a thing to make a decision based on. But if you just focus on frivolous lawsuits without that kind of guard in place, you will start to feel that you have to protect against every insane hypothetical, and you start reducing the effects of the bill. So focus on the good faith actor to the extent that they have a reasonable fear, which can be based on potentially frivolous lawsuits. You should think about that actor. So with that in mind, there's two particular principles you should think about as you're hearing testimony, and this is fortunately consistent with the exact principles set out in the memo that you received from the Coalition of Vermont Healthcare Organizations on April 19th. So first, think about certainty. Folks want to know, are they exempt, and are they clearly exempt? That's going to be a big piece that people talk about. You'll hear folks say, I imagine, they think that they're exempt, but because it's not clear in particular instances, they might incur compliance costs. So are people clearly exempt? And then if they aren't so clearly exempt, can they make decisions to protect themselves? Are there steps that they can take to reduce the impacts of potential litigation? Are there steps they can do to make themselves safer? And how do they deal with info that might not so easily fit into, let's say you're in a data level exemption world, how do they deal with information that might not fit into that? And we can come back to these pieces. I don't want to overload you with information, but that's one principle to think about: certainty. The other big piece is cost of compliance. And again, these two are intertwined too. A lack of certainty leads to unjustified costs of compliance. They'll have to incur costs if they have a reasonable fear of economically threatening litigation. And so anything that we can do to reduce that kind of unjustified cost is something that we should think about. And I will, at the end, hopefully be able to come back and talk to these pieces. So think about certainty and costs of compliance. With that, I'll return to the two pieces that we're talking about here and then hop out of the chair. The private right of action, the things you're going to want to think about. Can this be structured in a way that's targeted? We're just getting at particular kinds of harm that people can look to, just a couple places in the bill and know this is what I need to protect against. I need to think about 80 pages. And can the private right of action accommodate good faith compliance? So this is things like, is there a cure period in place, which is what the House bill accommodates or contemplates? If you have a cure period in place, what this means is a business can receive a notice that they're in violation, and then they can take steps to address it. And only if those things don't happen could someone bring a suit. That's a way of trying to limit the effects of that private right of action. You're trying to protect and accommodate good faith compliance. And this, we'll get into it later, but is tied as well to the exemptions, because if someone is truly exempt and they have questions, that's in a different place because they don't need to comply with the bill from which they're exempt, and we can talk about that. Another thing to think about with the private right of action is, do we need to minimize impacts on certain kinds of healthcare industry? I don't know, but I could imagine that you may have small healthcare industry or certain folks that you want to deal with differently. This is not something that we've thought about in the House side, and I haven't particularly thought about it here. But you could think about structuring the private right of action so that it only applies to particular entities and not everyone, but that's a question for you guys. So that's private right of action. And then to return to the last piece, exemptions. Can this be structured in a way to protect consumer interests while also not imposing those unjustified costs of compliance? And we'll come to this later, but you're going to have two poles here, data level exemption, and on the other hand, you have entity level exemption. And then you might ask yourself if there's a middle ground in between those, but we can wait for that until after this is done. And can we permit healthcare to operate as normally while still protecting data privacy? If that can be done, then that's kind of the ideal thing that you could achieve. So if there's a way of structuring the exemptions as well, even in a data level exemption world, where you permit folks to choose to just be compliant with HIPAA and not be compliant with the Data Privacy Act. In essence, if they could elect to treat data under HIPAA and not have to impose all kinds of compliance costs by generating, two different sets of privacy notice and all the sorts of things they would have to do if they had to deal with both HIPAA and the Data Privacy Act. If there's a way to eliminate all of those costs by just saying, hey, just deal with HIPAA, and if you can do that in a way that doesn't result in an entity level exemption, that's a nice place to be. With that, I will hop out of the chair unless you guys have questions, and let the folks who can actually speak to how this will impact them and the positive effects it might offer take the seat.
Questions for John? This was really a nice little umbrella for us.
Cool.
Thank you.
Great.
Yeah, good.
And
Thank you.
I'll be in here, so
And those are the two, the PRA and exemptions, those are the places where I think we're hearing the most. I don't know, let's not call it friction, but differences of opinion.
Getting a lot of attention.
It is good, thank you, that's exactly what I want to hear. Charity Clark is here, Attorney General, and thank you for being here, it's good to see you again.
It's good to see you. Thanks for having me.
My question for you, while you're here, we are also looking at S-25. So, will you be available for that one later? So we
Yes.
don't confuse our brains. Yeah, great. Okay, good, thank you. And you know everybody, so go ahead.
Nice to see everybody. I wanna, as a preamble, I have been working on data privacy issues for 6 years. And as a consumer attorney, I know a lot, I've seen a lot, and it's hard for me to be brief. So I'm gonna try really hard, but I have a lot that I could say and I'm not gonna say. I'm just gonna focus
We
on the
have
bill.
this online, can we get your testimony on our webpage?
You mean, have I written it down?
Yes,
Not really. These are just talking
okay.
like bullet points for myself.
If we could get some bullets.
Yeah,
that would be
I can do
great.
that.
Okay,
So as a preliminary, I enthusiastically support a comprehensive data privacy bill. This bill is very strong. There are a few things I want to highlight, that legislative council has also highlighted. But as a preliminary, just want to say how important it is that this bill, move forward, because there are other privacy concerns that will layer on top of this comprehensive data privacy bill. Other states have kind of, since we first proposed a bill like this in 2020, other states have sort of zoomed ahead. And now we have new data privacy concerns like artificial intelligence. And those need to be addressed. So it'll be nice to have this foundation. So really pleased that you're taking this up. And I know you're focused on a few specific areas. So let me talk about the recommendation that I wanted to make. The first that concerned me was the definition of biometric in this latest Senate version is, in my mind, very problematic. And the reason is that it excludes photographs, audio, and importantly, any data generated from a digital or physical photograph or an audio or video recording. Unless such data is generated to identify a specific individual. My knowledge on this comes from a case that we brought and continue to have going against a company called Clearview AI. Are you familiar with Clearview AI? In January 2020, a reporter for the New York Times named Kashmir Hill wrote a story about a startup company called Clearview AI. In essence, Clearview AI scrapes the internet, which means, I don't know, they have bots will say, that go out and take photographs from the internet and they face map the photographs so that they can identify people. They started out, the article is pretty disturbing because they were in startup mode, especially, and there's, their story of, I don't want to waste time. So I'm just we'll send you a link to the article. We at that time proposed in the House a Biometric Information Privacy Act to regulate the collection and use of sale and everything of biometric information. A journey commenced, including the pandemic, about that issue. But 2 months after that story broke, we sued Clearview AI for violation of the Consumer Protection Act. And the reason is they basically have tried to face map every person on Earth. They have 20 billion photographs in their database now. So they have roughly 4 or 5 pictures for every person on Earth. The algorithm it's incredibly sophisticated and impressive. It can recognize you when you're wearing a face mask. It can recognize you when you're in shaded. It does not discriminate. It doesn't say, oh, this is a private moment. This is a lady crying on the street. This is someone being proposed to. This is a lady breastfeeding. They can't say, oh, this is a lady in her backyard. This is a lady sitting in her living room and I can see her through the window because a tourist was out front and snapped a picture. This person doesn't even know their picture is being taken. Very disturbing in terms of like the ethos of privacy that we have. So our deep understanding of the real world potential for biometric data is largely based on our knowledge into that case. So for that reason, I was chagrined to see the change in this definition because I don't think that, well, first of all, this is on page 3.
yeah, we've got it.
So first of all, I wonder if it might conflict a little with the first, so 4A says this is what biometric data is. And one of the things, number 3, is spatial or hand mapping geometry or templates. Okay, how is that different from an exemption over in B3, which is any data generated from a digital or physical photograph? Isn't that what face mapping is, data? So I don't think this is, I think it conflicts. I certainly think it's important to not exclude, but include any data generated from a digital or physical photograph. I also want to emphasize this is a private company making money off of our faces. That's how they are making money. So one of the fundamental things about data privacy that always like gets me is that when someone takes our data without our notice, without our consent, and they use it to make money, I feel like I should have a cut, right? That's mine. I wouldn't let you like plant an acre of carrots on my, land and not want a cut of the carrots that you sell at the farmer's market. And so I just would urge you to change this. I don't want to belabor the point, but.
And thank you for that, because we had identified that as an
Oh,
area of
good.
concern.
The other reason why this is important, in general, why biometric data is so critical to, in my mind, regulate and put guardrails around is, I personally and my office have been learning a lot about non-consensual deepfake pornography. And there's other kinds of deep fakes that can be dangerous. I'm thinking specifically of in the campaign context, government context. We just had a deep fake of President Biden during the New Hampshire primary, you probably remember. And you can make those extremely easily using audio or video, but you probably have heard stories, and we're happy to direct you to some news stories if you haven't, about non-consensual deepfake pornography being used. And I mean, it's used with faces of celebrities, but the stories that are so haunting are the stories that are being used for children. And the impact on the mental health, and in some cases life, because I think that people are so ashamed, even though it's not them, it's just this. Anyway, so I emphasize the importance of audio and video and how those are used with the technology. And I'm going to talk about this a little bit, but it's really important that this bill have flexibility because technology is going to change, and you want to put language in place that's going to anticipate the need to apply that to a new technology. And deepfake is a classic example. If you told me when I first started advocating for this bill 4 years ago that was going to be a thing, I don't think I could have imagined it happening in 2024, and it certainly is happening. The second thing I want to talk about, which John also mentioned, is the private right of action. I have advocated, and I know I sent the chair an op-ed that I'd written a few months ago after the last session when this bill H121 was first introduced.
I think we posted it.
Okay, good. Yeah, advocating for private right of action for biometric data, and the House committee went further than that. But I had focused on biometric data because the first Biometric Information Privacy Act out of Illinois in 2008 had a private right of action, and it made a really big impact on the people living in Illinois, but also on the marketplace because of the requirement that large companies like then Facebook had to comply, and they were doing things that were outside of the boundaries of the law, and they had to pay a really big settlement as a result of that. But also Facebook became a safer place for us. So the private right of action has what's called statutory damages. Meaning there's a number in place. It said it's $1,000. I think it's still $1,000, or when the last version that had the private right of action was $1,000. We have a private right of action in the Consumer Protection Act right now. It's been in existence since 1967. It doesn't have statutory damages. It has actual damages. So you can bring your claim against the person, but it's actual damages instead of statutory damages. You can probably imagine in this context why providing actual damages can be challenging. Meaning, how do you quantify what the cost would be to make me whole if I've lost my data privacy, if you've taken my face, if you've taken even something like my social security number, how do you quantify the fear that my identity is going to be stolen? But when it comes to biometric data, you can't just get a new social security number, right? You can't just get a new face. And once the data is breached, once the privacy is violated, it's very, very difficult to get that back. And so that's why one of the many reasons why I've been advocating for this private right of action. I believe we shouldn't take that away from Vermonters. I think if someone's privacy is violated, they should be able to bring their own action and not rely on the Attorney General to do that. And also just from a practical standpoint, I mean, we have maybe 8 or 10 lawyers in our consumer unit. And that's, I don't think the taxpayers should pay for more lawyers to do that. I think that individuals should be able to hire a lawyer and pursue action when their privacy is violated in that context. The last thing that I wanted to mention, and I know others are here to testify about this, is with regards to consumer health data and the question of having an entity level exemption versus a data level exemption. This is another area where we want to anticipate the technology that's going to be developing as the years go on and this bill is in place. And there's going to be technology and data that falls outside of HIPAA and currently already falls outside of HIPAA. So if you want to rely on our Congress to keep up the pace, okay, but I think they've already failed to do that because there's already areas. And the other thing that I find, concerning is I think that it might provide a false sense of security to consumers who find themselves, at the doctor's office and they're getting their HIPAA, disclosure form and they're thinking I'm covered, not realizing there might be data that falls outside of HIPAA. That we either can anticipate or have already anticipated. I have a list of a few things that we kind of were brainstorming. I wonder if I can find them in my sheet here.
I was gonna ask you to give some examples of
Yeah.
data.
Didn't pick up my glasses, I'm sorry. Oh, here we go. I did see something else that I forgot to mention, which is that, Connecticut has been a real leader in data privacy, which is wonderful. The bill on the House side, is in large part based on them. But what we heard from them is this wasn't a good, this entity level exemption wasn't ideal, and they're trying to turn it back to a data level exemption. So they even are abandoning that, and it's great when you're not the first, so maybe it's all for the best that we didn't do what I wanted in 2020 and we had a little time, because then Connecticut passed their law and now we can benefit from their wisdom.
So find us your examples of the data outside, and I wanna ask you a question about what happened with Connecticut, or maybe you wanna do that first. What were the conditions that had them return to or go to?
Well, we heard from them, and I think they issued actually a report, so I wonder if we can find that and just get you the report.
I think it's on the webpage for the.
Okay. Yeah, so they issued a report that said that, and I think that they just said that they're running into problems with it. I don't know the specifics.
We can find out.
Yeah, and they actually, I think they testified on the House side too, so
Yeah.
they've been really helpful. Okay, but in the meantime, I did find my list. So here's just like the sampling that we kind of brainstormed. Health search information and browsing history, information collected and shared through apps and data collection, and storage devices that may be or in the future could be shared by agreement between patients, health tech companies and healthcare providers. So anyway, just
Just health tech companies such as the Apple Watch with.
the outside of the HIPAA, universe. I mean, that's just the thing, it's like you're relying on this law, which is very good law, but you're relying on it to cover all of these things that probably weren't even anticipated the last time HIPAA was taken up.
So, when we hear from our nursing homes and our AAAs and our hospitals and our FQHCs and our other clinics about wanting to be exempt and only covering HIPAA, how do you respond to that? What I'm hearing you say are things that are definitely outside of HIPAA. So there are some things that are there.
Right.
We get that. We understand that. But then we're also hearing what John was talking about, which is the fear element, and what do we have to do to make sure we're going to be in compliance. So, so from your perspective.
I mean, okay, so for one thing, many entities said they would also like to be exempt from this law, and I can understand why, because it's requiring them to do more work and potentially, exert expenses. I get it. The thing that also keep in mind with HIPAA, we have a lot of some of our most sophisticated nonprofits or companies in this state are healthcare providers.
Mhm.
So, I mean, we're asking the most sophisticated potentially among us to be exempt from the law. So, I mean, I just am pointing that out. I totally understand the tension. It's just a matter of striking the right note and knowing that if you go with an entity level exemption, there's going to be data that's not going to be covered. And for me, this is worse. We don't anticipate the data in the future that's not going to be covered as things evolve and technology evolve. We just can't imagine that right now. So if we say you're off the hook because of HIPAA, but there's no flexibility there. And that's the thing that to me concerns me the most.
Okay,
For both being members of the interstate compacts for healthcare, is that gonna compound this problem as far as?
we'll ask John Gray that question.
I'm afraid I don't know
You
about
won't know the answer.
that. Yeah,
I
I
don't
would,
think any of us will know the answer, but once you're in a home state, or once you're in a state and you're working as a compact member with a compact license, then you're regulated by the laws within that state, so that would cover that problem.
Sure.
And if you do something egregious, can lose your license here. And if it's really bad, you can go home and lose your license, so.
The other thing I would say about health data is the reason why HIPAA already exists and so many entities don't have a privacy law around them is because it's so sensitive. It's really, really sensitive information. The idea that would be an area where we would have an extra layer of protection isn't crazy because it's not, just your phone number, it's really sensitive data.
All right, so, it's too bad we can't make a statement about a distinction between data outside of HIPAA and. Okay.
Well-
Go ahead,
I think the bill already
tries to do.
does that. It sort of threads a needle where saying when you're covered by HIPAA, you have to abide by HIPAA, and then the things that are not covered by HIPAA abide by
Yeah.
this law.
Yeah.
And I think that, I mean, I remember John going through this and had marked it in here, that it strikes that balance that I think, the Attorney General's right, like some of our most complex and data-rich organizations in the state are healthcare organizations. And to exempt them as a whole, I think would be really putting a lot of data and consumer privacy at risk in a state that many other entities don't have that level of consumer data.
Okay, you don't remember why Connecticut was going?
What the complaint was, I mean,
Well,
let me ask Sarah, my Assistant Attorney General is
Okay.
here. Do you happen to know example?
Sarah Sevis, Attorney General's Office. I don't know offhand, but we can absolutely go through the report and we have to provide charities written testimony. We can provide those examples.
well,
in
that would
written
be helpful.
testimony.
We'll try to get you a memo by the end of the day that will
Perfect.
have all this info in it.
that'll be perfect.
Mhm.
Okay. Other,
I'm sorry, Connecticut, I was just looking on the State House's website. Is this the report that you're talking about?
Yes, that is.
That's the
okay.
report. Do you want me to send it to the committee?
sure, send it to Morgan, and then Morgan will send it to Megan, and Megan will post it.
Morgan Feldman.
Morgan,
Oh, okay.
Yes.
Morgan is Kiki. So if you
So
would
Madam
like to-
Chair, I was like sending notes to Kiki, telling her I was late. I didn't realize Kiki wasn't here today. So, okay, I will, okay.
Okay, questions for, our, go ahead.
Just one fundamental question, because I'm not operating in your world, but the private right of action versus the Attorney General's protection for the citizens of Vermont. It's not an and or, it can be both.
Oh, it would be both.
Okay.
Yeah,
This-
definitely.
this
I would have the authority, yeah.
Okay, very good.
And our, just so you, just as a point of information, our, under the Consumer Protection Act, the damages we pursue is different. It's $10,000 per violation per consumer. So it's calculated a little differently, just, but, yeah.
Other questions? Okay,
All right, thank you.
and we'll
Yeah.
look for that, that would be great.
Sure, thank you.
Need it. Okay. So Devin. Reeves.
Can we ask your indulgence to testify together?
No, I'm fine, but
Okay.
if you'd like to take a chair up, that's great.
Coordinate?
The more the merrier.
We're representing the coalition, so.
Okay, and that would be helpful for you to let us know who you are
Yes.
representing. So
Good morning.
What coalition?
We will tell you who we are. Well, Jessica Barnard with Vermont Medical Society.
And Devin Green with the Vermont Association of Hospitals.
And we've submitted a memo that Ledge Council has referred to a couple times, and it is not just on our own behalves. We are here, this is a coalition that came together way back in the early days of COVID. So it's a number of healthcare associations, and we still try to coordinate and work together where it saves you time in particular, so that you can have only one
Oh,
or two
this
faces
is my
in front
Star
of you.
Wars Alliance.
This is the Star Wars Alliance. This is the Jill Olsen Star Wars Alliance. And she
Okay.
is actually at a conference today, so we'll excuse her for not being here. But if you look at the memo, so it's the this is from the Medical Society, VAWS, Vital, and we know some questions about Vital and the Health Information Exchange have come up, the VNAs of Vermont, family physicians, pediatrics, bi-state primary care, the Vermont Healthcare Association, long-term care, Health First, which is the Independent Practice Association, Vermont Care Partners, the VAs, and Planned Parenthood. We know you'll be hearing from Jessica later, but she's also supporting sort of our memo and request for you to consider today. So why is this whole coalition coming to you together? What do we have in common? We do not sell healthcare data. We are also healthcare covered entities under HIPAA, which means we have extensive federal regulations that already apply to us. So the bill already includes exemptions for a number of entities. And that is because the Senate Economic Development Committee heard a lot of testimony about how they have state and federal privacy regulations that apply to them. So that's interestingly, the state itself. So think about all the Medicaid data, all the social determinants of health data, all the, all that data, the state is exempt. Financial institutions and credit unions, so all your banking data.
And insurance companies.
And I was gonna say, and health insurance companies. And third party
Insurance
administrators,
companies are fully
Correct.
exempt. It's
Correct.
not in the.
public service companies. Institutions of higher education with all your loan data and mortgage data. So why is this? It's not because we don't think that privacy is extremely important. It's because they have already comprehensive schemes to protect that data. Whether it's under state DFR regulations or state or federal privacy schemes. So we are here to explain a little bit to you, and I know you heard a little bit about HIPAA, but how HIPAA already protects this data. We're not saying we don't care about privacy, don't protect privacy. That's not at all what we're coming here to say today. But it's that how broad HIPAA already is, what it requires us to do. It's very parallel actually to a number of sections in the bill, just specific and targeted to healthcare. So for example, issuing a notice of privacy practices, you've seen those notices. Here's how we protect your data. Here's what you have to consent to. Here's what you opt in or out of. Obtaining patient authorization for many uses of data, limiting data to the minimum necessary, training for staff on HIPAA privacy requirements. And here's important, I'll mention this, but I don't know if we'll get into how much we want to get into this, but applying those same requirements to business associates. So if we're working with a billing company, or when we're talking to Vital, or sharing information, we need to have a very specific prescribed relationship with that entity, a written agreement, and then HIPAA actually applies to that entity as well. So your data, that follows that data when you're working with a business associate. And this is really important. HIPAA applies to online tracking technologies, websites, and mobile apps that are used by covered entities. I'm gonna be real, I'll say that again. HIPAA does not exempt. If you are using a patient portal, if that healthcare entity has an app, if you use a website and you're using cookies, HIPAA does apply to that. OCR, the Office of Civil Rights, the federal level, which enforces HIPAA, has a very specific guidance for healthcare providers about that, how to make sure your use of technology is also covered by HIPAA.
And I think that also goes to the point of, we don't know what's going to happen in the future. HIPAA is actually fairly nimble in terms of it can be done through rules. If they see new technologies coming out, like cookies, then it can address it through rulemaking. It doesn't have to go through all of Congress or get changed in that way.
And here's another, and enforcement for non-compliance. So I wanna go, I just was looking, as of March 31st, 2024. So how do you enforce your rights under HIPAA? You can, there's a very simple complaint portal on the Office of Civil Rights. They have received 356,000, actually, and 287 HIPAA complaints. They resolved 99% of those, investigated and resolved over 30,000 by requiring changes in privacy practices and corrective actions. They can also impose civil monetary penalties. So far, they have, I'm gonna say this right, $142,666,772 that they've imposed for higher level penalties. So it's sort of tiered. You know, there's corrective action, then there's penalties, and then in fact, there can be criminal violations as well. And there's breach notification requirements. So patients, if there's an over 500 patients involved, patients have to be notified that there has been a breach and what they're doing to correct that. The other piece, so that is all under the HIPAA privacy rule. That's kind of the confidentiality pieces, the pieces most patients are more aware of. There's a whole second rule under security. And this is another piece that I know people are really concerned about, sort of the cybersecurity piece of it. There's a whole second rule that requires a security audit. You have to go through any, so this is really more about how you're storing or transmitting the data and making sure that's secure. Are you, so this is why you now have to use a patient portal and don't just email your provider over an unsecured email, or you have to use secure email. You have to verify, you have to, if you're turning your lease over for your copying machine, you have to make sure that it's scrubbed of any patient healthcare data. You have to lock laptops and not have them encrypted in case an employee laptop is stolen. So that's a whole separate part. Then, just to mention, state law has adopted HIPAA as its privacy security standard. So that's in 18 VSA 1881. So not only could this be enforced at the federal level, but there could be state enforcement if you're violating HIPAA, as we've now adopted that as our state's privacy law. And healthcare entities can also, and many of them are, subject to federal regulation 42 CFR Part 2, which is further standards for substance use disorder treatment records. So we're already working under a number of schemes. Devin will talk a little bit more about 42 CFR Part 2 in a minute. So I want to come back to what problem are we trying to solve? And I appreciate if you just ask the Attorney General's office about this, because I have not heard examples that say what problem this will fix for HIPAA covered healthcare entities in Vermont. We do know there's a concern. We've heard you mention, and in fact, the Attorney General mentioned apps. Apps by non-HIPAA covered entities, like the period tracking apps you've been talking about, they are not HIPAA covered entities. They will be brought under this law. I think that's your right to be concerned about that. And we agree with them being pulled under this, the higher standards for sensitive data. But they are not HIPAA covered entities. Browsing history by a HIPAA covered entity is addressed by HIPAA. If it's a non-HIPAA covered entity, they should be pulled in, and they would be. So again, so direct patient, if there's not a healthcare provider or insurance company as sort of the intermediary, if it's a direct patient facing app, they are not covered by HIPAA, because HIPAA applies to the healthcare entities who have patient information. So that is an important piece of what this bill would add to privacy in Vermont, but it's not improved or changed or fixed by pulling healthcare entities into it. We also think that the way the bill is structured actually unfairly targets healthcare entities. And sure, there are big healthcare entities. There are also a lot, as you know, of very small healthcare entities in our state. Independent physician practices, mental health practices, small clinics. And we are mandated, rightly, to maintain patient records for 7 to 10 years. So almost all of us, regardless of how small, will exceed the threshold for exemption based on size. So we know Senate Economic Development heard a lot about, the smallest entities, the compliance costs, the challenges of even figuring out which data is in or out. Because we, by law and by standards of care, need to maintain patient data, we are, no matter how small, we are really getting pulled into having to comply. And compliance is not easy here. Again, I'm glad you asked the Attorney General what information is in or out. If we have a data specific exemption, we don't know. And our small entities don't know and are really worried about this. What is outside, what might that be that just HIPAA data doesn't cover? And how do we, and then we know we could treat that like HIPAA, but how do we treat non-HIPAA data like HIPAA? That there's no framework for that. There's no clear way. Would we then modify our notice of privacy practices to somehow talk about non-HIPAA data, but the notice is specific to HIPAA, so that exemption really is not clear enough. It's not, we don't know how we would comply with it, how small entities need to contact an attorney, a compliance assistance program to determine this. We're also really concerned that the attorney, we know that the Attorney General is charged with educating small businesses about how to comply. I don't think that's gonna be specific enough for healthcare entities. This is really a very granular determination of every, a data by data. Is this data in? Is this data out? Is it under HIPAA? We have concerns that that's not gonna be covered by general, here's how to comply with this law type of education. Sorry, I could keep going on. I will give that some time. I do want to mention, we're really concerned. You heard the example of a private right of action in Illinois. That's actually some of the most concerning examples for us, where we do know that there was litigation against nursing homes and hospitals, that they were violating the biometric protections by using fingerprint med cards, which is actually one of, I think, the standards for how do we protect narcotics and make sure the right patient is getting the right medication. That law had an exemption for HIPAA covered entities, but it was still litigated under a private right of action. Because it was unclear if that exemption was specific enough. I haven't read the full briefs on the cases, but that is, so, that is a big red flag for us. And so I think with that, I will let Devin get a little more into the confusion of operating under conflicting standards.
Yeah, and I will just say in that case, the court ultimately decided that that was not protected data, but again, I think it went to the Supreme Court of Illinois, like it was a lot of litigation. I think that just goes to the fact of we need to weigh the protection versus the cost of compliance and the difficulty of compliance and when providers may just shut down. So right now with HIPAA and data privacy, there's actually also another data privacy scheme that you've heard about, which is 42 CFR Part 2, which protects mental health and substance use data. And it applies, it's very similar, but it has a little bit of a different standard in some areas. And we've actually seen providers like primary care organizations who have hired a substance use disorder counselors say, okay, we're not sharing data with Vital anymore because I don't think we can share any of this data. And as much as an attorney will tell them, no, you can share the data. It's okay. Like this is good for Vermont to share this data. It helps with care coordination. It's allowed under the law. The primary care provider has just said, no, we can't risk the liability. We're not going to do it. And we know that sharing healthcare data, so we want to strike both the balance between the compliance piece and the cost of compliance, but we also know that in terms of healthcare reform, we do need some coordination of care and sharing of data. And so we are really looking for how can we ensure that we promote that going forward and we don't inhibit that. And I do think that relying on HIPAA, which is very protective again, and does respond to things like cookies and new technology and covers all those things, that would be the best way to help people going forward. When we went back to our providers after getting the current language that's in the bill, we said, you guys, we got this language. This is great news. This is a compromise. And they were all like, oh my gosh, we have no idea how this works. We can't do this. And we're going to have to just call an attorney every time we have data where we're not completely sure. And they're very, they're rule followers. Healthcare providers are rule followers. So they are either going to follow an attorney or they're just not going to share the data. And so having a HIPAA exemption really strikes that right balance where it encourages the right kind of sharing of data where we know we'll be giving people optimal healthcare while also protecting that sensitive data.
Oh, and one thing I want to mention, I don't think we talked about, HIPAA does also very specifically address marketing. Yeah, I know there have been some questions that have come up about that. It's basically you can, with some very small exceptions, you cannot market. You use patient data to market unless the patient opts in. So very similar to 121 approach. So it does address that very clearly. There's guidance, just like websites and cookies, there's guidance on marketing. It is very comprehensive as a scheme. For protecting privacy.
Thank you. Questions? Go ahead.
We have heard a lot of the importance of continuity of care, especially for folks in the medical field. It sounds as though you feel that if we were to go ahead with a private right of action, that would stop or be diminished or and ultimately have consequences on the health provided to patients in Vermont.
Yes, definitely, yes, I think John did a really nice example of explaining the conflict or not the tension between clarity of the exemption and a private right of action. I think if we had a very clear entity level exemption, a private right of action, then our entities would be clear doesn't apply to them. So if you wanted to apply it to bad actors out there, we're sort of indifferent. But the way the exemption is drafted right now, we're sort of half in and half out, and so it very well could apply to us, and we've seen how the impacts of that in Illinois. I've been waiting, I have to give you this example, I've been waiting for every committee to talk to you about this bill, I have to give my example of the Medical Society had a teeny grant from the Department of Health to do education around refugee health. So we had a webinar series on refugee health, and we had guest speakers who gave these lectures, and then we posted their talks, their slides to our website for people who missed it. Not all, lots of entities around Vermont do this, and education around refugee health, great thing. We get a demand letter, a couple months later from an attorney out of California saying some of these images are copyright. We have been hired by, I won't name the name of, a publishing firm on behalf of their photographers. I'm sure the photographers had no idea, didn't see any of this money, but, here we have a very convenient portal, pay $5,000 per image and this will go away. I thought, scam, ignore this, whatever this was. No, I ignored it for a couple weeks. Oh, now we're gonna charge you $1,200. If you don't reply right away. So I said, if this was for education, I think it was fair use. No, we don't care. They still had we took it down immediately as soon as we heard this. Don't care that you took it down. The rights, copyright still doesn't care that you took it down. We still have, violations for distributing this without permission. So I reach out to a number of entities. We don't have money to hire an attorney. We're super small. What do? We reached out actually to the Attorney General's Consumer Protection Division, reached out to various entities. This sounds horrible, but sorry, we don't represent people with this issue. Finally got a free consult with an attorney who said, you know what, just pay the money. Yeah, you might have an argument, you could fight this, but do you want to? We think this is it's kind of scammy, but they actually do kind of have a, copyright violations. Yeah, you use their image. So there are shops set up, just talking about scrubbing the internet to look for that. And then I've been talking to other, I've been raising it. A lot of nonprofits have been hit with this sort of type of challenge to their, so you could say right to cure. We thought we took it down immediately, but no, that didn't give compensation for past violation. You still owe us damages. So that's the kind of scheme I think, so if we think some of our data is in or out, but then maybe we didn't do this notice exactly correctly for this other type of data, and somebody sees that notice, could they bring, I just think it's opening up fear, unknown, concern, risk, and having to hire attorneys to help answer all these questions.
Well, okay, thank you. So I don't think that example is relevant to this.
Okay, tell me about, yeah.
I mean, I think that that's a horrible, crappy thing you had to deal with, and but I don't think, and that isn't about sharing data. That's about sharing what was allegedly copyrighted material. So that's a totally different area. So while I think I think what sharing that example in this context is just kind of fear mongering. So I don't think it's relevant, but I'm not an attorney. And what I think that also sharing healthcare data with other entities, that would still be covered under HIPAA if we didn't provide an exemption level. Healthcare entities would still follow HIPAA when it comes to healthcare data. It would just be the non-healthcare data that would be covered under the data privacy law. So things like financial data, fundraising data,
Financial data is HIPAA data.
Patient financial data is covered.
Well, but that it's provided in a different context from healthcare providing. There's data that in particular, large hospitals have that is outside the bounds of HIPAA that would be covered under this. Anything that's covered by HIPAA, you would still follow HIPAA. So any of the financial data that is covered by HIPAA. So I generally, it's to provide an extra layer of protection for non-HIPAA covered data. And so the examples of sharing healthcare data, you would still be under the same scheme that you're under right now.
I think we need to know, I think we don't know that, to be clear, like where the line exactly is on. I think that I'm concerned actually that the Attorney General cannot give clear examples of this, because we also, like, our members are also confused about what's in or what's out.
I think the comment,
Specifically.
though, I just wanna say, I wanna kind of move us along and make sure others have a chance to ask questions, but one of the comments you made was how to identify, define, and treat non-HIPAA. So we don't, I have asked a lot of people, what is the non-HIPAA stuff, and it's hard to find it. So
And it's hard to find what problem that's, like, if it exists, what is the problem we're trying to solve with it?
Yeah.
Right.
We think we do a pretty darn good job of following HIPAA and complying, and that HIPAA also accounts for if there are violations, how to enforce, how an individual enforces those rights, and gets relief if there has been a violation.
And I do want to be clear, it's larger than just your healthcare data, it's also patient financial data, all patient financial data is included.
good question.
But not if it's shared in a non-comment data.
Okay.
Super fast.
We're getting into conversation, we'll get there. So you have a question,
Just
go
a
ahead.
sort of question / comment. Correct me if I'm wrong, I don't think you were fear mongering. I think you were trying to give an example of what the scrubbing of the internet looks like.
Yes, I was not just saying that that's the same legal scheme under which you would bring a complaint under this law, but saying it is very easy to find technical violations of a very complex, detailed compliance requirements. And so, right, it could be scrubbing for your policy of how you comply, yes, it was an analogy, not saying it's the exact same situation.
Got it, thank you.
Okay, other questions? Okay. Quite a place to be. So I thought of an example, probably not a good example, but I do remember when there was a underground garage being built, and the question was, where did the financing come from? That wouldn't be covered by HIPAA. If it was for a hospital and an underground garage was receiving financing from an entity that wasn't perhaps allowed or disclosed, that wouldn't be HIPAA.
Sorry, it just, I'm obviously not the best position to offer hypotheticals. I live in a world of words and other things, but the thing that I'm thinking about, and I think it's the idea that you're getting at, is if you had a entity level exemption, say for covered entity, business associate, no tie to the particular kind of data. If you had some institution like hospital or small clinician operating in dual capacities. So they have this one stream of revenue, they engage in healthcare, but they also do other things that are not healthcare. They do those other things. They're exempt as a covered entity. They don't have to comply on their second revenue stream if they are exempt at an entity level. Now, maybe people could make the argument that they're only exempt in their capacity as a covered entity, but if that's the case, I think you can't just use the language, or it's less clear to me if the language exemption for covered entity is sufficient, because they are a covered entity, they just also are acting in this other capacity. And so if you wanted to draw that out, to me, the language starts going in a direction like institutions acting in their capacity as a covered entity. And to me, that feels the same as the data level exemption, because you're then having to make an analysis, and maybe it's an easier analysis, so maybe that's the whole point. But to me, it feels like you're still getting in the question of there has to be analysis, and I took that to be the point of that's what generates fear and compliance costs. In the absence of certainty, having to make an analysis generates costs. So it could be something that institutions in their capacity as X, if that's an easier analysis to make, maybe that reduces compliance costs and maybe eliminates the possibility of folks acting in dual capacities, hospitals taking other revenue streams. I don't know how if this ever happens, but that. Like, you.
Right. You don't run that I did an example to that.
Okay, go ahead.
So thank you, John, that's really helpful as always. So UVMMC is now creating housing for its employees. And so if there's an entity level exemption, the housing data that they collect from those employees would be exempt. And it's not covered by HIPAA. So that's what we want to protect, that data, because they are acting, that's not healthcare, it's different data completely. And an entity level exemption would exempt them from everything they do because it's an entity. So I
That's a
think
good example,
I
and
think
so
that's-
going to what John was saying about drawing a line, and then for that, for the entity level exemption with respect to the work that they're doing as a healthcare, organization. And then the second step, I'm saying something else, the second step I would say is, we don't know how to identify, we haven't identified all the other data, and we don't know what it is. We haven't defined it, we don't know how to treat it, so that's another step, and I know there's something we all love in here, report, there's another section of the bill that has reporting. Maybe there's some language we can add that would help clarify, because I'm not interested in stepping off a cliff or having folks leave the State House with that sort of lack of certainty. So just some thoughts there. So we'll just hold that thought for now, because we also have another person to testify. Jessica.
Good morning, Jennifer Barquist. I am the VP Public Affairs for Planned Parenthood of Northern New England and the Planned Parenthood Vermont Action Fund.
Good morning.
Good morning. Thank you so much for having me. So I am a part of the Healthcare Coalition, but I am going to put those issues aside for now. And the main thing that I want to talk to you all about is the geofencing provision. And the committee had a discussion last time about the intersection between this bill and S-173. So I just wanted to walk us back a little bit and remind the committee about S-173, which
what is that?
you all took
Lots
up.
of bills.
Yeah, you all took up this bill at the beginning of the year, and it was the healthcare data privacy bill that was modeled after language passed in Washington State. And the language that is in that bill is widely seen as the model for protecting consumer health data with respect to sexual and reproductive health data privacy. We were very supportive of that bill. We came in and offered testimony in this committee speaking about the importance of keeping that data private. And I highlighted some of the concerns we're seeing with respect to sexual and reproductive health data being used to target people, particularly pregnant people, who are either thinking about abortion care or maybe have experienced a miscarriage. Shortly after that hearing, I learned about the work happening upstairs with H121.
So did we.
And you did as well. And so I worked with your chair and with the committee upstairs and shared with them our concerns and our requests and the bill language of S-173 with the House Economic Development Committee. And that committee graciously worked with us to understand those needs and to ensure that the language in 121 adequately covered all of the provisions found in S-173. So I know you all didn't get a side by side and the language is different, but want to kind of assure you that the intent is very much in alignment and that this bill protects an individual's sexual and reproductive healthcare data in all the same ways that S-173 would have. And so the one I really wanted to talk to you all about, the one that we feel is really, really important for our work is the geofencing provision. And the only real difference between S-173's language and this is that this language defines a square footage boundary, which I actually think is a really good addition because it gives clarity on how far around a healthcare facility one is prohibited in the geofencing. And I know last week, when you all were talking about this provision, there were some questions about, whether or not you would want to do just a straight prohibition on geofencing. So no consent, just no geofencing allowed around healthcare. And I did do some research and tried to see if there are other purposes or reasons why a geofence would be used in a healthcare facility. And I, my limited research skills acknowledged, I didn't find any. And, knowing what I know about running a healthcare facility and the intersection with HIPAA, it seems very unlikely that a healthcare provider would use a self-marketing tactic like a geofence. So we would be really comfortable with a straight geofence prohibition, even with consent. And I also know the committee went back and forth around whether or not to include the kind of examples of why a geofence is used. Again, I couldn't find any other examples of why one would be used. And so I think that's definitely a committee decision around whether or not you want to include those reasons in language or not. I definitely think it's not an all-encompassing list. And so I don't see the harm in listing it out, but could support that either way.
So in terms of the bill on the geofence language, it's a strong bottom line.
Yeah, I think this is strong, and this is the language that has passed in any other state. But if you wanted to take it a step further and say, under no circumstancing is geofencing allowed around a healthcare facility, we would support that as well.
Is there an exemption for, in this particular case, for law enforcement? Because I'm kind of like turning the tables completely. You might want that protection as opposed to not, wanting in.
Yeah, so law enforcement isn't specifically mentioned, but my sense is if law enforcement is doing something like that, it would not be called a geofence. And they wouldn't be
I don't want
using
you to
it.
overreach is my point.
Yeah, and maybe that's a great reason to keep in these specific examples of tracking consumer healthcare data for the purposes of marketing and the language that's already in there to really clarify that that's what we're talking about, is that self-marketing technique.
So would pregnancy centers be included in that?
If it's clinical center, yeah. And I think as defined in our bill that we passed last year, it would be included.
Yeah, they're included in the definition in this bill as well as we read it under the sexual and reproductive health care center.
I feel like I would be in favor of like an all-out ban on geofence.
We can talk about that.
Because I also think it could be used for other things besides marketing. A geofence could also be for surveillance and, surveilling who's going in and out and then collecting that data and saying, oh, like Martine went there or Ruth went there, whatever.
Yeah.
And we've seen that in other states where they collected data on folks who have walked into Planned Parenthoods and then sold that data. They sold data of over 600 patients for less than $150. So that is part of what we're trying to prevent, is that surveillance of consumers and healthcare facilities.
So, when we have Ledge Council come back up, we can talk about the limits. What we might want to do. Anything else?
The other point I was just going to make, and you've already touched on this a little bit, is the distinction between apps that track sensitive health data and the healthcare data, and the conversation you all had last week around the period tracking apps and menstruation. And just remind you all that in 2021, Flow Health, which is one of the most popular period tracking apps, settled with the FTC over allegations that it shared health information on its 100 million users with third-party data analytics firms. And this was part of what we were attempting to remedy in S-173, and this language here would very much prohibit apps and websites from, and as well as search engines and advertisers, many other entities, from selling, collecting, and sharing people's health data without their express consent. And I did a little side by side of the bills myself to make sure that those privacy policy requirements mirrored one another, and they both required clear and conspicuous disclosure that clearly defines uses on how that data is collected, stored, processed, and shared. So we feel really comfortable that the language in here is going to offer the protections that we're really looking for with that sensitive health data. And we know that the world of data is ever shifting. And so this is one of those places that I anticipate we might have to come back and revisit that language and make those additional clarifications over the years. But for what we know right now, we're really satisfied with this language and the intent of this section.
This is why we need a technology committee in the Senate.
To revisit,
Because it should be like a
Visiting,
regular revisit.
yeah, I know. Amazing. Anything else? Committee questions for Jessica? We're good.
Thank you so much.
Thank you very much. So, John, we've got 5 minutes before we hop on to another bill. Do you want to come up briefly? And I think what we will do is after this, we will take a little break. If we need it. So things that we've heard, and so the biometric piece that we talked about last week, where we wanted to include those things that have been excluded.
We can do that very easily. I have language already ready on that point, so that one's simple.
Okay, we like simple. It's always complex. So then the other one is with regard to, so we heard things about PRA. The PRA is already in statute and the AG can
Yep.
do X, Y, and Z. Or what would be the difference here with private right of action that the Attorney General currently cannot do?
So I think what we.
Thinking mostly of healthcare.
Sure. So I think we had talked last time about specifically crafting an in-act private right of action. It would not hinge off of or piggyback off of under the underlying consumer fraud protection statutes. And what it would allow you to do is just to spell out specifically what you want to achieve here. Now, you could use the underlying, but it's kind of nice for people to have one place to look and see this is what you're subject to. There is one thing I wanted to call out. Because I recall that the Attorney General was stating that one nice feature of the consumer fraud statutes is that it calls out actual damages, and so that it would permit recovery of damages for things that go beyond economic harm, so things like emotional distress, reputational injury, and the like. We can do that just as well in a standalone in-act private right of action. I'm not saying that you necessarily have to do it that way, but there's nothing unique about the underlying that makes it the only vehicle for that. In fact, the House bill actually contemplates the greater of $1,000 or actual damages for harms. So that would contemplate all kinds of non-economic injuries there. So that's something to just be aware of.
Okay, and then the other question is with regard to what is outside of HIPAA. So if there's an sort of the institutional exemption.
Yeah.
Is there language we can put in about language that's outside of that? And then add in some the reporting language, because we need to identify what this stuff is, what the data is that we're talking about. Define it and how to treat it. So that's not clear.
So,
How do we,
right, something like foggy.
but it's okay.
The thing that I would like to say on that particular point is the bill generally treats data without needing, is meant to be very capacious. So the fact that we aren't aware of all of the harms and contemplate the possibilities of data is both intentional in that it's meant to address potential future harms, and also a reflection of the fact that we have really limited time. So aren't able to get all kinds of testimony on what sorts of harms are happening in other places. So there is a reason that if the data is defined generally and broadly and is capacious and it's meant to accommodate all kinds of harms that could happen to you. So that is an intentional part of the bill and the approach taken in other states. The exemptions piece, I did want to say, I had a proposal, although in some ways it's not that responsive to the testimony that we heard today. I thought that we might hear folks say they're having to make the determination, under the current data level exemption, what you see is that the protected health information has to be processed by these particular entities in accordance with HIPAA. So I thought we might hear folks say, we have to conduct an analysis whether we've done it in accordance with HIPAA, and if they aren't, they're actually subject to two enforcement regimes, both OCR or Department of Health and Human Services at the federal level, and the Vermont AG if they violated HIPAA, because they
This
would,
is the
wouldn't.
subject to piece.
Exactly. So what I was gonna say is there's sort of a, we didn't hear a lot in this piece, so maybe it's not super responsive to it, but you could switch this in accordance with to subject to, and what that would mean is that as long as the protected information is subject to HIPAA, meaning it falls into that category, whether or not folks are processing it in accordance with HIPAA, they only have to deal with HIPAA enforcement. They don't have to deal with the Vermont Data Privacy Act. They may violate HIPAA, but then those enforcements would come under the federal regime, and they would just worry about that piece. They wouldn't need to have a separate compliance mechanisms in place to address it. I don't know that that resolves all of their concerns. I do think if I was health industry and I was trying to get, and we were in a land purely of data level exemptions, I would prefer to have subject to language to having in accordance with language, because it reduces the amount of analysis that you have to do. It means there's only one enforcement regime you're dealing with, just the federal HIPAA regime, and not a duplicative HIPAA plus AG. But if you switch to an entity level exemption, I think you have to question about the entities operating in dual capacities, which we put hypothetical on. And then in that case, I do think you probably want to do something like institutions in their capacity as covered entity or business associate under HIPAA. So hopefully that's helpful context, but
That actually sounds good, because the more we hear, the less we know. I mean, so,
I'll be silent next time.
yeah, no, this is good. Senator Hardy.
Yeah, I think, I wanna make sure that these large complex entities that are doing multiple things are covered, when they're acting as a healthcare provider, they're covered under HIPAA, but when they're not, when they're acting as a landlord or a developer or a fundraiser or whatever they're doing, you know, a marketer, that they are covered by this act. So if that's how to do it with what you just suggested, that acting under the capacity, I think that sounds good, so that we have them fully covered and not exempt from this law, or obviously HIPAA and their other capacity.
And the affirmative head nodding that I saw at that time suggested to me that that may have been the intention of the proposed exception, was that it would only apply to the extent that someone is acting in that capacity.
It seems that way.
I did want to pause and just note something I did say at the outset, which is the data level exemptions we have for healthcare data in this bill track what Oregon does. So I did just want to call out that this is an approach taken in another state to deal exclusively with data level exemptions for healthcare industry. But I think that obviously all the concerns raised today are legitimate, and I would say in particular, the point about not being certain how to take advantage of the exemption 24/7 AA, which is about if you can treat non-HIPAA data in a HIPAA manner, is really important testimony to receive, because that was proposed as a way of reducing compliance costs for folks. As like here, you may not know what to do with non-HIPAA data, but you already know how to deal with HIPAA, so why don't you just treat it like HIPAA? Folks really don't know what to do with that exemption, then it doesn't reduce compliance costs, and therefore you aren't gaining the benefit that's meant to be received from having that kind of language. So institutions in their capacity is definitely an approach you can take.
Can I just note one quick thing? So just looking at this Connecticut report that we mentioned earlier, and it does, one of their recommendations is to scale back entity level exemptions. They say, while Connecticut's law creates blanket exemptions for entities covered by grant leach by the Bliley, which I think is for financial institution, and Health Insurance Portability and Accountability Act, irrespective of the data involved. California and Oregon's laws are appropriately limited to data covered under these laws. So if what we have currently in the bill is based on Oregon,
It is.
then what Connecticut is suggesting is
It's
that
what
we should go
Oregon
to
is doing.
Oregon, which is what is in our bill.
What's in it?
Yes.
So I'm a little concerned about messing with it too much because,
So maybe there
Based
is
on
some
that.
language that you could put together that would provide, so the exemption for the, just, it sounds like it's gonna be belts and suspenders, to be quite honest. Protection for the health data, HIPAA protected data, and, but.
So do you want the institutions in their capacity language? Because if you're just doing the data level exemption, that's what we have here.
Yep.
But
Yeah,
I mean, obviously, I don't take a position on any of this
Yes.
stuff. I do think it's fair, folks' testimony about reasonable fear and induced compliance costs, but it's you guys' call to figure out, and like I say, another state's taking this.
no,
Approach,
incapacity is,
You like the institutions in their capacity.
yes,
Okay.
very much. And then as part of the reporting process, I think we need to have some further, there needs to be further analysis of what the rest of that data is. So is it the landlord? Is it the developer? What is it?
So you want to add something like that to the report section as just to say, kind of analysis of this harms were analysis of anticipated harms for, I mean, this is really a broad bucket, is that, like, it's a very big bucket of things.
I don't know how to do that. Let's think about that.
And I think this is again, just, I realize this isn't super helpful to you guys, but it is in part, the situation that you're in is in part a response to no one has the time to take all the testimony on potential harms, so
Exactly.
that's, yeah.
Okay. Okay, one last thing, and then we're gonna take a little break, but go ahead.
what did we decide on the geofencing? And
We haven't done that one yet.
And what did we decide on the private right of action?
We haven't.
Okay, because,
Yeah.
that would be included in whatever amendment we're.
What do we,
John's-
let's just talk about private right of action first. So what we heard is it should be targeted. Can we review what we heard from the
Yes.
ASG
Oh.
and then, yeah, that would be helpful. You have the breadth of this, I do.
Yeah, just so for the prior right of action, I was saying, if we can be targeted so that folks know exactly what kinds of harms are being dealt with, they know where to look. And if it accommodates good faith compliance, that's something like having a cure period to allow people to comply. I will say, just for you guys' purposes, if you do the institutions in their capacity as covered into your business associate under HIPAA, this ties into how hard you need to think about the private right of action. Two, it's not how hard the Senate as whole needs to think about it, but you will be addressing a lot of folks' anxiety about the situation by having that approach. So I would say if you target it to things like 2419 V2 processing of sensitive data and 2426, which is your consumer health data sections, that's a nice way to do it. And then you can include the cure period to permit people who are good faith actors to comply and then not be subject to suit. The other piece was if you wanted to consider thresholds or something to minimize impacts to a particular industry. I don't think we've heard testimony today to affect that analysis, so I don't know that you need to undertake that. And again, I will just note that the act is not effective, this particular piece, until 2025, so you can hear testimony next year if there are
Well, we
modifications.
could
that need to be
also
made.
ask for a report back about size of organization and putting some of these questions into that.
It'd be like an economic analysis of
Yeah.
compliance costs on
Yeah.
smaller industry or something like that.
All in
I like what John just
Yeah.
said about the private right of action with the cure and the,
Right, it's in the bill. Cure is in the bill. It's, I believe. so-
For the AG, but if
The
you
AG, but
introduce
if we
the
put
private
it
right
in
of
for
action, you would
healthcare,
need
yeah.
to include it for that as well.
Yeah.
Yeah.
It I know it was a different context, but it sounds like the cure period is kind of useless. I mean, that you're still gonna be sued even with that in there.
So you can make it such that the consumer doesn't have the right to sue unless they've taken particular steps. So in the House version, what it is the consumer has to be harmed, basic requirement, and then they have to provide notice to that controller or business process or whatever it might be. And then the controller is afforded a 60-day period in which to comply. And then if they don't, at that point, only then can the consumer bring suit. So technically, what you're talking about is, I cautioned at the beginning about thinking about the bad faith litigant. You can have people who just show up. You have an uninformed like well-meaning actor, and they say, you need to settle with us, and it never goes to court, someone just pays out a few $100, whatever it is, because they don't want to deal with this headache. That's a bad faith litigant, that's a bad situation to be dealing with, and at a certain point, you're making an analysis of where do we put the risks, like, that's a conceivable thing, and so the way to me to address that is with education and outreach, rather than with introducing additional provisions to limit, say, bad faith actors.
Just
If you
don't
get
use those pictures.
Yeah, like let people know that that's not a step that they shouldn't need to respond in that way. If someone shows up, they're permitted these particular things, and yes, if it does go to court, they will have to undertake costs to deal with it. But maybe you can eliminate a lot of bad faith stuff just by letting people know, here's what you do in these kinds of situations. So building out education and outreach, I think, is in some ways responsive to that.
Yeah.
All right, so geofence?
Did you guys want to drop so I like having purposes language because
Yeah.
we don't know what permissible kinds of geofencing are out there. Maybe there's not. Part of why I like having narrow, maybe it's just like a legalistic mindset, is it's easier for us to say than if a law is challenged that we were really targeting specific harms. And so we did it for this reason, this reason, and this reason. We aren't trying to overreach in any particular situation. So to the extent that we can be sensitive, it's nice, but I take the point that if there literally are no permissible uses of geofencing around the healthcare industry, then you would just want to prohibit it. Probably, and unfortunately, it's an empirical question that I can't tell you the answer to. And I do want to say on the law enforcement piece, I'll need to think more about this, but I think that law enforcement would be subject to, so this is identifying someone on the basis, now I don't know if they use geofencing to do this, but if law enforcement uses geofencing and they're using it to trap a particular person that enters a healthcare facility, I think this would be picked up by that prohibition. And the fact that we have a construction section that says shall not be construed to limit a controller's ability to cooperate with law enforcement agencies. I don't know that that's so cleanly picked up. I can think more about that, but it's fair for you to be concerned about that if that's, and I don't know how law enforcement uses geofencing if they do, but that's something to be aware of.
That's,
Well, I
that's a
think-
judiciary question. They all, there's a lot going on right now with this.
We could also have
Oh,
bad actor law enforcement from other states.
Exactly.
Oh, yeah,
I think
no,
that's
You know,
specific.
that's all
Texas
right.
law enforcement tracking people going into a clinic in Vermont, and I don't want that to permitted, I don't care, I don't want it permitted, cause I don't want them tracking people going in and out of a clinic, so.
but yeah, so there, it does get broad too, because you start having clinics and schools. We've got clinics all over the place though.
Well, we shouldn't geofence around schools either. I mean,
I did.
There we are. Okay, well, geofence.
Healthcare.
What is the committee's pleasure on geofence?
draw a line.
So from a-
Straight line, sorry. No, you go.
From a previous project. In an unnamed Middle Eastern country,
Oh, God.
we use intelligence from geofencing routinely
Yeah,
for purposes of security.
protection.
Yeah, and so I would not want to support geofencing that didn't allow law enforcement or intelligence operations. But I think that, as John pointed out, the detailed reasons for geofencing, I think they're appropriate. And I support that 100%. I just don't want to take it too far.
Right.
Because I do think, and I do know that there are actors who take advantage of.
Yeah.
What page is it
So
on?
leave that,
Geofencing should be around
and then, no, for the purpose, leaving the purposes.
I mean, I would, but I can,
For healthcare, we're talking healthcare. here.
I would want to just completely ban geofencing, period.
exactly on 50.
For healthcare.
Page
Because
54.
that's.
Yeah, if you're
that's
talking
healthcare
prohibition,
facilities.
um,
Yes,
Yeah.
using
that's what
geofence, like you're talking about the
Okay,
definition,
that's
it's
what
probably
we're saying.
page
Okay.
so
four.
the purpose section has
Yes,
the
page
healthcare pieces in it.
Well, page,
The prohibition on geofencing is page 50.
we made a decision. 24 and 26?
That's correct.
Yeah.
Because it's any notification regarding the consumer's health data.
But also has the identification piece.
I know, but if it's for the purposes of identifying a person or other, because they are just there, I think there's a way to get around this if for, law enforcement from Texas or whatever.
Well, they can get a warrant. I mean, there are different ways that law enforcement work that other bad actors don't work.
Well, I'm just saying they can use this geofencing to say, oh, this person from Texas came to Vermont and went to a clinic in Vermont. We don't want that. And
Does it matter what state they're from regardless?
no, but Texas is the one of the states that
Yeah,
has
no, I get that.
really restrictive laws and also are leading toward tracking people in other states.
So it raises another question too, just about applicability in the first instance, which is, it's true that the numerical thresholds don't apply for this section because we're talking about consumer health data. But it still is the case that the initial piece of the applicability section, which is persons conducting business in Vermont or targeting products or services to Vermonters. So I don't know, this is a happy answer because we have different positions at the table on this, but it conceivably law enforcement, they're not falling into those, but like Texas law enforcement, they're not falling into those buckets. They're not targeting a product or service to a Vermonter. They're not conducting business here, I don't think. And therefore, as a whole, this act doesn't affect them, like in what they're doing, because the no person shall piece is still of the 24-26 is still restricted by the requirement that they meet those other applicability sections. So I can think more about that, but
Okay, let's do that. Let's let your brain work on this one, and we will as well. And then we'll try to come back to this tomorrow. We have it on the schedule.
cool.
We're gonna try and look at some lines, so between now and tomorrow, maybe we could we'll have a final discussion at the end of today, because I'm aware that we have folks waiting to testify on S-25 right now.
Okay.
This is an important decision.
I can come back informally and talk later today.
That would be great. Yeah, that would be great.
Cool.
Thank you very much.
Thank you.
It's been very helpful.
See you guys. Yep.
Okay. I was gonna take a break. I think we have enough time as long as the folks that are they all?
Just happy.
Okay, and Matt Chapman is somewhere. All right, so committee, can you take a 5-minute break and hold it for 5 minutes?
Yeah.
I know this committee. And I know.
Not just this committee, are you kidding me? I can never get